Namaskar. The topic that we are going to discuss next few minutes is Committee of Creditors, role, meetings and voting. So those who have been associated with insolvency and bankruptcy code in any manner at any point of time over the last 5 years since its enactment are well aware that the code has brought in a paradigm shift in the model of insolvency resolution from debtor in possession to creditor in control model. So creditors exercise control over the process of resolution under IBC as a committee through the resolution professional. And this committee is known as Committee of Creditors or COC for short. I have prepared a small presentation to facilitate the delivery of my talk in a structured and sequential manner. So we'll go with that. Who would comprise the Committee of Creditors? This question was deliberated by the Bankruptcy Law Reforms Committee, the committee which recommended the framework for enactment of IBC. And after deliberations, this committee found that financial creditors should comprise the Committee of Creditors. So before we go into the rationale and findings of the BLRC, let us see who exactly are the financial creditors. The term financial debt is defined in the Insolvency and Bankruptcy Code in Section 5, and from there we can derive the definition of financial creditors. So financial creditors include creditors from whom money is borrowed against payment of interest, or the amount is raised by issuance of debentures, bonds, or any other instruments. Creditors who have guarantees or indemnities of the corporate debtor. Creditors under lease or hire purchase contracts. Or in case of a real estate project, the allottees of the real estate units who give advance to the corporate debtor also are called financial creditors. So these are mainly the financial creditors, and related parties to the corporate debtor will not be included in the Committee of Creditors even if they are the financial creditors. In case of a corporate debtor where there are no financial creditors, Committee of Creditors would consist of 18 largest operational creditors, one representative of the workmen, and one representative of the employees. Now, why only financial creditors to be a part of Committee of Creditors? So, as I told, Bankruptcy Law Reforms Committee deliberated on this as to who should be on the Committee of Creditors, given that the powers the Creditors Committee will exercise will ultimately keep the entity as a going concern or will end up in liquidation. The committee reasoned that the members of the Creditors Committee have to be creditors both with the capability to assess the viability as well as to be willing to modify the terms of existing liabilities in negotiations. So typically operational creditors are neither able to decide on matters regarding the insolvency of the entity nor willing to take the risk of postponing the repayments for better future prospects of the entity. So the committee, that is BLRC, concluded that for the process to be rapid and efficient, the code will provide that the Creditors Committee should be restricted only to financial creditors. Now, importance of the Committee of Creditors has been emphasized by Honorable Supreme Court also in various judgments. One of the judgments by the Supreme Court in the matter of Swiss Ribbons Private Limited versus Union of India, the Supreme Court observed that The financial creditors are in the business of money lending. Banks and financial institutions are best equipped to assess viability and feasibility of the business of the corporate debtor. Even at the time of granting loans, these banks and financial institutions undertake a detailed market study, which includes a techno-economic evaluation of business, financial projections, etc. Since this detailed study has already been undertaken before sanctioning a loan, and since financial creditors have trained employees to assess the viability and feasibility, they are in a good position to evaluate the contents of a resolution plan. On the other hand, operational creditors who provide goods and services are involved only in recovering amounts that are paid for such goods and services and are typically unable to assess viability and feasibility of the business. These are the observations made by Honorable Supreme Court in one of the judgments. Committee of Creditors is bestowed with a responsibility of taking commercially wise decisions for the revival of the corporate debtor in the interest of all stakeholders. So in another judgment, Honorable Supreme Court, in the case of ArcelorMittal India Private Limited versus Tish Kumar Gupta and others, emphasize on the role of Committee of Creditors. These are the extracts from the judgment of Honorable Supreme Court that ultimately it is the commercial wisdom of the requisite majority of Committee of Creditors that must prevail on the facts of any given case. The NCLAT judgment, which substitutes its wisdom for the commercial wisdom of Committee of Creditors, must therefore be set aside. Through this judgment, the judgment of NCLAT, which had some bearing on the decision taken by the Committee of Creditors, was set aside. So thereby, once again, Honorable Supreme Court recognized the commercial wisdom and the supremacy of that commercial wisdom of the Committee of Creditors, and thereby bestowed a great responsibility on the shoulders of Committee of Creditors to achieve the objectives of the Insolvency and Bankruptcy Code. In another important judgment, that is K. Shashidhar versus Indian Overseas Bank, again, Supreme Court observed that the resolution professional is not required to express his opinion on matters within the domain of financial creditors to approve or reject the resolution plan under Section 34 of the IBC. At best, the adjudicating authority, that is NCLT, may cause an inquiry into the approved resolution plan on limited grounds referred to in Section 30, subsection 2, read with Section 31, subsection 1 of IBC. It cannot make any other inquiry, nor is competent to issue any direction in relation to exercise of commercial wisdom of financial creditors, be it for approving, rejecting, or abstaining, as the case may be. So these a few judgments of Honorable Supreme Court and the observations of BLRC indicate the importance the Committee of Creditors plays in the entire in the resolution of the corporate debtor under IBC, and the responsibility that everybody in the law has placed on the Committee of Creditors. Now, what are the roles and responsibilities of Committee of Creditors? COC exercises ultimate control over corporate debtor during the insolvency process. COC exercises its control through the resolution professional, and continuation or replacement of the resolution professional or interim resolution professional is decided by COC. COC has to finalize the eligibility criteria or the terms for resolution of a corporate debtor, which are comprised in RFRP, while the RP has to confirm the legal compliance of a resolution plan. COC has to decide on the feasibility and viability of the resolution plan, which needs a commercial evaluation of the plan. COC is vested with the authority to take decision on resolution plan for a corporate debtor, which decides either the restoration of the corporate debtor or its liquidation, depending upon approval or rejection of the plan. COC also has the powers to negotiate the terms and commercial aspects of the resolution plan so as to maximize the value of the corporate debtor in the interest of all the stakeholders. COC has to approve various decisions which are taken by RP for successful resolution of the CD during the course of CIRP. Now, the importance of the decisions taken by COC on the resolution plan can be viewed from the fact that it will decide the fate of several employees and workers of the company. It will also decide whether a corporate debtor is going to be revived, thereby preserving the economic assets, valuable economic assets of the country, which are contributing to the growth of the economy. And it will also decide that how much contribution this corporate debtor will continue to make to the exchequer. So in that sense, the role of Committee of Creditors is very, very important. Now, it is the role of trust, the trust that the law has placed on the Committee of Creditors, that all the stakeholders place on the Committee of Creditors. So what are the roles that Committee of Creditors plays? So we can see COC is a process custodian. So the entire process of insolvency resolution should be run in a transparent manner and in a manner which is compliant with law. This is the responsibility of COC to ensure with the help of a resolution professional. And the process is to be aimed at achieving the goals of or the objectives of the code, that is the value maximization. COC also has control over the assets, while the resolution professional will have physical custody of the assets or the possession of the assets, but creditors, that is the COC, will remain in control through their decision-making powers at a meeting of the Committee of Creditors, and RP is supposed to take those approval from the Committee of Creditors from time to time. Now, next role that COC plays, COC is a fiduciary for all these stakeholders. Other stakeholders include workmen, employees, government, departments, suppliers, other creditors, operational creditors. So all those stakeholders rely on the competency and expertise of COC, and to that extent COC has to ensure that the conduct of COC is fair and equitable to all the stakeholders. The process of resolution of insolvency cannot be and need not be and should not be viewed only as a recovery process. COC has to ensure that it aims at ultimate long-term survival of the corporate debtor and balances the interest of all the stakeholders in that process. COC is also a guardian of public interest. As I already said, that the prime objective of the code is to preserve the economic value of the asset, and thereby decision making by COC will be in the larger public interest by preserving the economic value of assets. Now, what are the expectations from Committee of Creditors by various stakeholders? COC has to assess the feasibility and viability of a resolution plan with transparency and objectivity. COC has to choose a management or the new owner of the CD who will be the resolution applicant, and that should be a most suitable management to keep the CD as a going concern on long-term basis. COC has to make the best efforts to arrive at the most suitable resolution plan and to negotiate with the resolution applicant for value maximization. COC has the responsibility to choose the best resolution plan from out of the several options available during the course of resolution process, and COC has to have an unbiased judgment with the intention for overall resolution of the CD. CD has to balance the interest of all the stakeholders, already said. COC has also to oversee the duties of the resolution professional to keep the CD as a going concern. COC has to follow the highest standards of integrity in all its decisions, because the decisions of COC will have far-reaching implications for various stakeholders. CS has to ensure that due process of law is followed. Now, Committee of Creditors, how it exercises its voting powers and how the meetings of the COC are conducted. Meetings of the COC will be conducted as per the process laid down in the regulations of IBBI, CIRP regulations, and the permitted attendees for the COC meeting are chairperson, who will be the resolution professional. RP will chair the COC meeting. Financial creditors, who are the members of the Committee of Creditors, they will be the members of COC, they will be the participants to the COC or their authorized representatives in case of class of creditors. These members of the COC, the financial creditors, they are entitled to exercise vote at the meeting of COC or after the meeting of COC on various issues that are discussed in the Committee of Creditors meeting, and based on their voting, the decisions are either approved or rejected with the requisite voting percentage, which we will discuss later. Other participants in the COC meeting can be operational creditors if their aggregate debt is 10% of the total debt based on admitted claims. They are allowed to attend the meetings, but they do not have any voting powers. They can only be observers in the meeting. The erstwhile suspended board of directors of the Committee of Creditors is also allowed to participate in the meeting of COC, but they also do not have any voting powers. They can be observers in the meeting. And apart from that, financial creditors who are related to the corporate debtor, they can also attend the meeting, but they do not have any voting powers. So the only participants in the Committee of Creditors who have voting powers are the financial creditors. Meetings of the Committee of Creditors, the relevant provisions are laid down in the insolvency resolution process for corporate persons regulations, and the regulation 21 lays down the relevant norms for that. Minimum notice for the meeting of Committee of Creditors is 5 days as per the regulation. And the regulation also empowers the COC to reduce this notice period to not less than 24 hours. Quorum for the meeting shall be the members representing not less than 33% of the voting rights. Meeting is to be held as and when required when the resolution professional convenes a meeting, but the first meeting has to be held within 30 days of appointment of interim resolution professional. That is the date of commencement of insolvency resolution process. If 33% of the members of COC requisite and request resolution professional to convene a COC meeting, then it is obligatory on the part of resolution professional to convene that meeting. If any issue is presented or any matter for discussion is raised by the members of COC with 33% voting rights, then that matter has to be discussed in the COC, and RP is supposed to place that proposal in front of the Committee of Creditors for discussion and decision thereon. Notice for the meeting must include the list of matters to be discussed and the matters to be voted upon, and all the relevant documents to facilitate and enable the stakeholders, participants of the meeting to take a decision have to be submitted along with the agenda. Audio-visual mode for conducting the meeting is permitted. There are certain conditions for that. The participants in the meeting should be able to clearly see and hear the proceedings. They have to maintain the confidentiality of the proceedings. No unauthorized person should have access to the proceedings of the meeting. With those conditions, the meetings are permitted through video conference or the audiovisual means. Minutes of the meeting are supposed to be circulated within 48 hours of conclusion of the meeting. And it is the responsibility of resolution professional to circulate the minutes of the meeting within the given time. Now, voting. Voting by the Committee of Creditors, Regulation 25 of CIRP regulations deals with this aspect. RP has to circulate the agenda to be voted upon in advance along with the relevant documents. Voting may be physical during the course of the meeting itself, or it can be through an electronic voting system post the conclusion of meeting and post circulation of agenda. Whenever the voting is through electronic voting system, the voting has to be kept open for minimum 24 hours from the time of circulation of the minutes. An agenda is taken up as approved only if members with requisite voting share, and the requisite voting share is, we will be discussing in the next slide, when they with the requisite voting share vote in favor of the agenda, then only it is treated as approved, and that percentage, requisite percentage voting share applies to the total members, total voting power, and not the members present and voting. If any member doesn't vote on an agenda, he shall be deemed to be not in favor, meaning thereby those members who abstain from voting, their vote will be treated as a negative vote. Only explicit yes or concurrence vote will be treated as a vote for approval of the agenda item. Thereafter, if there is any change in the voting at a later stage, it will not invalidate the proceedings that have already happened in the previous COC meetings. COC takes decision with requisite voting share. The law lays down, the code lays down the percentage for taking decisions as 66% or 51% based on the matters. So, taking a decision on the resolution plan for its approval or for the liquidation of the corporate debtor would require 66% voting. Appointment of an interim resolution professional as RP, continuing as RP, or replacement of the RP would require 66% voting. There are certain matters which are referred to in section 28 of Insolvency and Bankruptcy Code. All those matters like raising interim finance, changes in relating to the ownership or management structure of the company, changing relating to security interest or the capital structure or related party transactions. These are certain things which would require 66% voting share to be approved. Extension of CIRP period beyond 180 days for further 90 days also requires 66% vote. And there are other operational issues which would require a simple majority, that is 51%, approval or modification of eligibility criteria of the resolution applicant or the bid evaluation matrix, ratification or approval of CIRP costs, reduction in the notice period from 5 days to any lesser time, not less than 24 hours for convening of meeting of COC, or similar other matters which do not specifically require 66% voting under section 28, they will require 51%. And withdrawal of the CD from the CIRP process under section 12A would require minimum 90% voting share. Committee of Creditors can also be represented by authorized representatives when there are a class of creditors like a home buyers in a real estate project, or when there are many debenture holders and they appoint a trustee to represent themselves. So these authorized representatives, when they exercise vote, in a committee of creditors meeting, they will be representing the whole class for the purpose of taking the decision. And within that class, 51% of the class of creditors, if they approve a particular plan or particular decision, then the representative will vote on their behalf as a class, and the vote percentage will be counted as per the voting share of the entire class of creditors. What are the key takeaways with regard to the role of COC and the importance of the role of COC? Key decision-making power vests with the Committee of Creditors, as already discussed in the beginning of the talk, that the role of Committee of Creditors is extremely important, and the fate of many people depends on the decisions taken by COC and on their commercial wisdom. The commercial wisdom of COC has of late been discussed a lot in several quarters, and that puts a more responsibility on the shoulders of COC to be more vigilant and to be active in participation in COC meetings. The people who are participating in the Committee of Creditor meetings have to be well equipped to understand the process, and they have to be capable to take a decision on the spot so that the process is not delayed and they are able to discharge their duties. The duty which the law places on their shoulders, they are able to discharge it with efficiency and able to achieve the objectives of the court. Thank you very much. Namaskar.